Peymon who?
Matahede.
Peymon Latahede. Who is he?
Never paid taxes in 30 years. Fought the U.S. tax court and won.
See, I believe our rights come from God, not from government. Welcome, everybody, to Freedom Law School's Freedom Hour. I'm Peymon Motahede, the president of Freedom Law School, which I created in 1996, helping you live free of the deception and fraud of the Internal Revenue Service. We talk about this gobbledygook called the Internal Revenue Code, the Bible of the IRS. We make it simple, have you be completely legally and safely income tax-free, payroll tax-free, even corporate estate tax-free by following the law as written on U.S. government's official legal websites at freedomlawschool.org. So with that, we're going to talk about the topic this evening about the Supreme Court overturning a case called Chevron. Okay, a lot of people have asked questions. Well, does it affect the IRS in any ways, and if so, how? So we're going to cover that topic at this presentation. So let's first go to the Supreme Court case that this stems from, called the Loper Bright Enterprises versus Raimundo, Secretary of Commerce. This just came out and decided June 28, 2024. And the U.S. Supreme Court, in this case, you know, the holding or conclusion of the court is right here, that the Administrative Procedure Act required, that's a congressional law, requires courts to exercise their independent judgment in deciding whether an agency has acted within its statutory or lawful authority, and courts may not defer to an agency interpretation or understanding of the law simply because the statute is ambiguous and the Chevron case is specifically overruled. Read pages 7 through 35 of the case. So with that, we're going to go over a few key parts of that case and then apply that whole thing to the IRS. Okay? So here we see in this case, into different parts are worth noting. The court says that in the interpretation of the meaning of statutes or laws passed by legislatures like Congress, as applied to justiciable controversies, was exclusively a judicial function. That's right. The judges decide something, a controversy, in a court setting, in an issue of justice. That's all where they start saying things. That's a well-known thing everybody knows. Courts are there to judge what's law, what's not, what's justice or not, right? So with that understanding, basically, now we go on, then they continue. Then the case called Marbury versus Madison, ruled by Supreme Court right after the Constitution was ratified, very soon thereafter, that the courts decide legal questions by applying their own judgment. And again, well-known principle of law, constitutional law, and it specifies that courts, not agencies, will decide all relevant questions of law arising on review of an agency action. When the government agency has done something, the courts at the end get to decide, hey, was this done right, according to the law and the Constitution or not? That is where the courts come in. It's their job to do so. And then the Supreme Court continues by saying that the Chevron case is unworkable and needs to be overturned. That the defining feature of the framework is the identification of statutory ambiguity. See, this term statutory ambiguity is a key thing. You're going to hear that again in this presentation. When the law is ambiguous, okay, and the agency is supposed to come up with the regulations to put the fine-tuned details of the law, that's what they're talking about. You see, In my opinion, there should be no regulations at all. The law is made by legislature, and that's it. But way back in late 1800s, the Supreme Court allowed Congress to pass laws that the railroads could not rip off people and charge too much for tickets to ride on the train going from east to west and other places, which was very popular at the time. That was the mode of transportation because it was much faster and efficient and less risky than riding on a horse and buggy. So they let the Railroad Commission set their rates that are fair and just for the railroads. So that's is a background of how that stuff started. In my opinion, it's unconstitutional because, setting the rates doesn't matter what. The Congress one makes the law. The agency cannot do that because they're not lawmakers. Okay, so with that understanding now, let's get back to presentation. When they delegate the lawmaking power to the agency, and when there's an ambiguity in the law, that's what they're talking about. They said used to be that the courts were required, the Chevron required the courts to defer to the agency, okay, of that their interpretation of the law, the ambiguity, okay. But they say the ambiguity has always evaded meaningful definition. When is a law ambiguous? When it's not. That's subject to your opinion, my opinion, his and her opinion. So that was the issue they mentioned is a key thing, the problem. And under the Chevron case, a statutory ambiguity, no matter why it is there, becomes a license authorizing an agency to change positions as much as it likes with unexplained inconsistency. That's right. The agency, basically, but with the Chevron case, are allowed to change course even when the Congress has given them no power to do so. They say the law is ambiguous. We're going to rule this way about the law should be applied this way, but then they're saying years later, maybe that way is more accurate. Maybe this is actually better. With gun owners, they try to do that, by the way. Recently, the Supreme Court shot that down, that they're just going all over the place. Okay? And then Chevron cannot be reconciled with the Administrative Procedure Act, APA, by presuming that the law statutory ambiguities are implicit delegations to agencies. In other words, they say that you cannot assume just because law is ambiguous or vague, impliedly it delegates to agencies to make law, because after all, the agencies are part of the executive branch. They can not make law. Only legislature, that we the people, you and I, everybody, we elected, they can make the law, okay? And ambiguity in the law is not a delegation of law interpreting power. Yep, just what I was sharing with you guys. And Chevron itself reaffirmed that the judiciary is the final authority on issues of statutory construction. Even Chevron itself said that way back then, okay? But they deferred too much, to the agency's interpretation of the law, okay? The view that interpretation of ambiguous statutory programs amounts to policymaking suited for political actors rather than court is especially mistaken. Well, that's not the way they should be, they say. So by forcing courts to instead pretend that ambiguities are necessarily delegations of authority to the executive branch of government agencies, Chevron does not prevent judges from making policy. It prevents them from judging, because judges are supposed to be judging cases. That is their job. Okay, they gotta be judging. But the way Chevron said, well, the judges cannot judge. You have to defer to the interpretation of the executive branch agency, and that's what's being now here overruled by the U.S. Supreme Court. Okay. This court, for its part, has not deferred to an agency interpretation under Chevron since 2016. In other cases that came up, they did not defer to the agencies. They said we went with our interpretation. So the saying really Chevron was not exactly at those cases analyzed and discussed and overturned, but here we are now going to really do it right as we wanted to and need to do so. And then they mention that again, Chevron allows agencies to change course even when Congress has given them no power to do so. Again, they repeat this big point that, executive branch should not be given the power to change the law. The law is only written by the people that we, the people, put in place, the legislature, the Congress in federal cases, not the agencies. They are not answerable to the people directly anymore. They never were. And then now the Journal of Accountancy has an interesting article about this. They talk about the case called the Mayo Foundation. In 2011, Mayo Foundation for Medical Education and Research, in that case, the Supreme Court resolved a split in the lower courts, the split of difference of opinion in lower courts, and held that Chevron deference applied to interpretive tax regulations under Section 805A, which gives a general grant of authority to Treasury to prescribe all needful rules and regulations for enforcement of the code. Okay. Before that case, the courts had generally given a lower level of deference to Treasury interpretive regulations. They were given a low level of delegation for the agencies to write the regulations. Okay. Now, the Internal Revenue Code has changed its manual to eliminate the statement that most regulations are interpretive and not subject to procedural requirements under Administrative Procedure Act. Okay, so these findings suggest that Treasury devoted more resources to promulgating regulations once tax regulations were held to be eligible for Chevron deference. That's a lot of gobbledygook, but I just want to mention that to you just so it's there. I don't want to spend too much time on this part, but because I want to get the main part coming up here. In the short term, a nullification of Chevron would mean that much of the day-to-day regulatory framework for tax will be put on hold and litigated. That's the key. More things will be put on hold and litigated about the interpretations of the tax law. Okay, and in the longer term, Congress will need to be incredibly specific in the statutes it passes. Okay, that's right. Well, that's what Congress needs to do.
Yes, sir.
It's their job to do that, to make a law clear and specific for everybody to follow. Okay, and this will be difficult in the current political environment, as getting anything done in Congress is the chore. Well, good. Things done in Congress should be a chore. Why? Because we don't want all these mountains and mountains of law. The Founding Fathers intended for laws to be simple, short, easy for everybody to know, and therefore easy for everybody to follow. Now that they make it so voluminous and they allow the agency to make that law even more voluminous by allowing them to make regulations based upon the law, it's becoming even much more voluminous and convoluted. Well, guess what? It's going to simplify and lessen the amount of laws that people have to follow. Wow. Okay, in America. So it's a good thing that the laws will become more specific as they're passed. So it doesn't really affect things, though, as far as us and the freedom movement is concerned. Why? It doesn't affect us in much serious way because we don't deal with all that. You see, this book, the federal tax laws, the Internal Revenue Code that the IRS follows, the Bible of the IRS, okay? Over 10,000 pages of gobbledygook, tissue-thin, small fonts of PhD-level English language written deliberately to confuse you, right? We don't even play in this thing. That's not mainly for us. We don't belong in there. That applies primarily, this internal book, federal tax laws apply to citizens and residents of Washington, D.C., federal workers. Sometimes it applies to certain activities within the U.S. territories, federal territories like Guam and Puerto Rico and Virgin Islands. They apply that much to people of the 50 states like oil taxes. You don't have to pay any federal income taxes, payroll taxes, corporate taxes, estate taxes, gambling, wagering taxes, even gun manufacturing taxes in the 50 states. Because that book does not apply to you. It applies to people outside of the 50 states like Washington, D.C. and or territories at some occasions. So we don't have to play in this jungle at all. This jungle of gobbledygook is not for you and I at all to worry about all these regulations. Chevron was overturned or not. It just basically doesn't matter. We just stay out of it. Because guess what? The founding fathers of America meant for you to not be a slave, meant for you to be a free man and woman. They did not have a bloody revolution, put their lives, their fortune, and sacred honor on the line for their children and grandchildren to become slaves. And you're not a slave from now on if you choose not to be a slave. That's right. In the past, you were deceived to believe you got to file income tax. No more. You no longer have that deception. The road is open for you to be free. So I'll show it to you briefly. Go to freedomlawschool.org and restore freedom by taking the 7 steps to regain your power and freedom. This way, you will never again voluntarily pay the Washington, D.C. swamp legally and safely guaranteed. The 7 steps, folks, are easy. All you gotta do is just, as you drive around in your car, going to work, to and from work, shopping, exercising, activities, whatever you're driving around, listen to them. And then when you get home for lunch or dinner or work, watch on your smartphone or computer, and you see it's all there. Number 1, you got to follow the law. We are sticklers for the law. And you'll see for yourself in 9 minutes that based on the U.S. official legal websites of the U.S. government, no law requires 99% of Americans to file and pay income taxes, okay? The proof is in our videos, and there's more videos about this topic in more detail, short videos, and then long videos. Now, the next thing people ask is about Peymon, but I gotta file an income tax to be safe. No, you don't. You got to stop filing income tax forms. They had you believe that filing is a safe thing to do, but no, it's the opposite. You put the rope around your neck when you file a 1040 form under penalty of perjury, under oath. You swear it's all true, correct, and complete. You see, when you sign a 1040 form, you put the noose around your neck. How? It's simple. You state under oath that you owe the IRS money. That's right. You said it, not the IRS. You claim you owe the IRS money, and based upon that now, you authorize the IRS to audit you, empty your bank account, steal your property, and even put you in prison. That's right. So check that out for yourself and disabuse yourself of the lie that you should file to be safe. That's the opposite. And then, folks, step 3, you get to realize the IRS is over 99% bluff. And these cartoons folks have here just exemplify the fact that the Wizard of Oz is at work. The Wizard of Oz have deceived you, the major media, that IRS is such a scary monster, be afraid. We're going to get you. But guess what? They don't. They're leaving non-filers alone. There's 80 million non-filers out there. They just brainwashed us to believe that we're weak, we should be afraid, and be a slave by signing a piece of paper under oath to our master. Master, I tell you how much I owe you under oath. Please go easy on me. Okay? So then once you get through that, step 4 for you to be free is take courage from our victories. Because, folks, no student of Freedom Law School has ever gone to prison for federal taxes, nor had their paycheck or bank account levied or home or business seized by the IRS. Never. That's right. This cartoon tells the truth about the IRS being a myth, a fraud. Okay, but you gotta check it out for yourself to be free. Okay, we've done this probably for over 20 years. Okay, and our students have all been free if they came to us clean and stay with Freedom Law School. Then, folks, you need to question authority, folks. Yeah, It's simple. Write to your Congress members. File pay income tax only if your congressman can show you the law that requires you to file and pay income taxes. That's right. If they show you, there's a law requiring you to file and pay income tax, go ahead and do it and let me know. I'll do it too. I'll start filing myself. But they cannot do so. Not once they've done that. We've done these petitions thousands and thousands of times. People done it so many times on their own, with or without us. And not once one lawmaker shown us wrong. Not even once. So go and verify this all for yourself. And then, folks, after this, if you want to be protected even stronger, you want to join the Restore Freedom Plan, if you have the spirit of the American Founding Fathers within you. If you are a man of conviction, of truth, of courage, of knowledge and wisdom, rather than ignorance and fear and cowering down to lick the boots of these people that want to be your masters, if you like these courageous men, then this club is for you, my friends. Yes. For modern day Founding Fathers of America, the privilege of 100% guarantee is available. No one else has ever had anything like this ever in America. No one. This is absolutely unique, available to Freedom Law School if you decide to hang together with other like-minded, truth and freedom lover men of God like yourself, my friends. So, bottom line is, by joining hands together, now you can enjoy 100% guarantee when you legally stop filing and paying income taxes. And as long as you are a member of Restore Freedom Plan, Freedom Law School will prevent the IRS from levying your money, or Freedom Law School will reimburse you, and you will not go to prison whatsoever for tax stuff. So if that's such a good deal, folks, all that's left to do for you is just tell other people. Join. Again, step 7 is optional. To spread the word, folks, we would love for you to become modern-day Paul Revere's and expose American people, families, to the truth about the law and Restore Freedom America. Once again, we'll be happy to pay you. Yes, we're going to pay you, compensate you, reward you for opening your mouth, be modern-day Paul Revere's, and have America be a free country once again. So with that, folks, go to freedomlawschool.org and continue your journey to freedom, folks. I cannot do it for you, folks. I'm just only one guy. Okay, at the end, the key to freedom for you is in your hands, not mine. All I can do is lead you to the water and let you drink the water if you choose to. So choose knowledge. Choose seeking the truth. Choose take the time in your car, listen to our videos, and at home later watch them again for review and making sure it's true. And you will be on your way to freedom, peace of mind, joy, prosperity, and freedom like you were meant to be. Thanks for watching.